Hello everyone, we are back with another episode of our podcast series where we discuss the importance of communication in the legal field. I am Anurag.
I'm Vinny.
I'm Harshit.
And I am Anas, and we are students from National Law University, Delhi. I will be moderating the discussion for the day. For today's episode, we have Mr. Nipun Saxena as our guest. Mr. Nipun Saxena is a practicing advocate in the Supreme Court of India and various other high courts. He is a graduate from National Law University, Delhi. He has appeared before many tribunals and quasi-judicial authorities, some of them being NGT, NCDRC, taxation, and various other tribunals. He has authored and contributed in various international and national publications. He was also associated with the Additional Solicitor General of India. He had worked on various landmark judgments. His field of interest includes constitutional law, civil and criminal procedure, property and real estate laws, white-collar crimes, environment laws, policy laws, and media laws. Hello, sir. We are honored to have you here, and we are very grateful to you for sparing some time from your busy schedule and joining us for this podcast.
Thank you so much for having me over. It's such a wonderful feeling. It's almost like homecoming, considering it's my colleagues who are interviewing me. It's such a pleasure being here.
Yes, sir. So, sir, how is it going in these pandemic times?
Oh, it's very, very hectic, surprisingly. There's a lot of work which is coming in purely on the urgent side of things. There are orders which have to be passed with respect to individual cases which require urgent interim intervention by the court. And so there's a lot of work for us because now that the things have gone virtually, it becomes very, very essential that despite physical infrastructure being shut down or, in the process of being shut down, individual liberties and human rights, human rights have to be protected. So I think it's a wonderful experience. It's very, very educating. It's very, very illuminating. It keeps us on our toes because we never know when a new notification prescribing a new format of practice and procedure may just come to our inbox. And so I think it's very challenging but very rewarding.
Definitely, sir. It's a tough time for all of us, and we hope that you are keeping safe in these times. And so, just going back to the phase of law school, when you started your journey in the law field, we just saw on your LinkedIn profile that you've conducted various legal aid camps in Central Jail, advocated for the prisoner rights, conducted prisoner advocacy programs to secure bail to prisoners. So how do you see the role of communication when it comes to counseling of prisoners? And not only for prisoners, but in general for the client counseling that you do with your clients. So what should be the way of communicating with them so that everything that is useful for the case can be obtained?
Okay, let's divide this question into different parts, right? Part one is my experience at law school. Part two being, of course, how did it shape up how was my experience with the prison inmates who were there, who were to be liberated. And third is general client counseling, right? So let's talk about the law school part. I knew from the moment I stepped into law school as to what I had to do. I was one of those very few people who knew from day one what they wanted out of their experience at law school. For me, it was litigation. For me, there was no other option, no other area of law that I wanted to try my hands on. Some called me obstinate, some called me stubborn, some called me, they gave me various adjectives. But I stayed my course. And this is where NLU Delhi was in its founding years. So in 2008, 2009, there were many, many individuals who had to decide whether to take up different law schools such as NLS, NALSA, NUJS, or try their luck with NLU Delhi. But we had a very dynamic leadership, under Professor Dr. Ranveer Singh. And he said, go ahead, do whatever it is that you want to do, and I will support you on an institutional level so long as you bring me results. And I think that was a fantastic contract that was entered into between the administration and the students. And students gave it their all. So what happened was that we came across a particular provision in the CRPC which was very underutilized. It was called Section 436A of CRPC, which essentially entailed that any person who has been accused of an offense for which there was a maximum penalty prescribed, and if that person had been an under trial, which is to say being languishing in prison for half of the maximum term, then that person was entitled to be released on bail forthwith. Now, let's say, just to give you an example, suppose theft carries with itself an imprisonment term for 3 years, and you already spent 1.5 years out of those 3 years, then you're entitled to be released on bail. And we thought if this is the scenario, then there would be so many inmates who would have been released almost automatically, because the word used in 436A CRPC is shall be released and not may be released. So it's no longer discretionary, it is mandatory for the person to be released. But to our shock and dismay, we found out that the total capacity of Tihar, which at that point of time was not over 7,500, had close to 12,000 inmates being stuffed into that prison. And when we, with the support of the Tihar legal aid officers and so many other wonderful persons, it became possible for us to have access to those documents, which should say date of arrest, the offenses under which an inmate is booked, and for how many months or days is the person in prison. And from that, we were able to cull out how many of those people could be benefited by 436A CRPC. So now you know that Tihar jail is not one jail, but many jails combined into one complex compound. So we went jail-wise, we went cell-wise, and in our first semester itself, this was when we were in our first year, in our first semester itself, we were able to dig out close to 22 people who we thought could be benefited by Section 436A CRPC. Now comes the challenging part, representation, asking them whether this is in fact true, or are there any other provisions under which they are booked. Say for instance, somebody may be booked under in FIR, there may be 2 provisions, but by the time charge sheet is filed, those 2 provisions may increase to 5 provisions. You see? So you have to constantly be in touch with the client, of course, not client, but the inmate, and they have to constantly ask that person as to, elicit information, find out what is going on in hearings, because a person cannot be traveling on every day to the court. And most of these inmates are clueless. All they want to do is get out of it, right? So we also come across so many people who gave so many different stories. So those stories had to be counter-verified with the documents which were available with the prison authorities and at the court, with the court records. Accessing that becomes very difficult because you are a student, right? You are not a lawyer, so you can't file wakalatnama, you can't have power of attorneys and so many things. So the thing that we did was we dug out this provision called Section 32 of the Advocates Act. It basically says that notwithstanding anything contained in this act, any person who is not even a lawyer can move an appropriate application before the court seeking its permission or seeking leave of the court to appear and argue for whatever categories of people that they were, right? And so we used that provision. We started filing applications before the court. The courts were very generous, knowing that there are students from National University Delhi who are appearing in court and getting those bail orders. Because an unfortunate part of the entire narrative is that the legal aid officers or the officers of the Legal Services Authority, the lawyers who are impaneled, were not doing that good a job back then. I'm not sure what the situation is right now. So you see, we filed those applications, and in our very first year, we had a cent% record of having 22 inmates released. I know this as a matter of fact because we were part of that founding core team that did it. And by core team, we don't mean that, there were other people who were running around. It was just these couple of members who were doing a fantastic job at running around and getting bails. I personally remember having argued 6 such cases, and in all those cases, of course, the person was released. So I think it was deeply rewarding an experience, and it because it was one of those experiences where we were learning on the job. You see, as law school students, in first year you don't have a brush with CRPC. You only read CRPC in your second year, right? But we dug out so many commentaries, found out judgments which would apply, started making submissions. We were very, very naive. We were very, very, at the time when we were making our submissions before the court, we thought it was just another moot court exercise. To our surprise, we found out that it was not so. But the judges, God bless all of them, were so accommodating that they essentially allowed all our applications that were filed with such amazing results. And then later on in our second, third year, we found out that the Honorable Delhi High Court has taken a suo motu cognizance of the issue and decided that automatic release would be ensured in all such cases where 436A CRPC's benefit could be given. So you see, hundreds and hundreds of people could get out because of that wonderful initiative that was started by the National Law University Delhi's Tihar Prison Advocacy Project.
Definitely, sir. And it's really motivating for us as first years that you can achieve whatever you want to do. Even though we are not familiar with CRPC, but we did get to know what exactly is the idea behind it. But sir, you did mention that from the very starting you were focused about litigation, sir. But that's not the case with all of us. So what exactly was the idea behind it? Or even in my particular case or for my batchmates, so how should one find that particular interest?
See, I wouldn't advise that my way was the best way to decide or determine your career. I think you should always be experimental. You must focus largely on the internships, on the kind of work that you're doing, on the areas of law that you find your interest in. And it is then and only then that you can take a call. Many people have not their calling even after they have graduated, even after they have spent almost 2 to 3 years. 2 to 3 miserable years in what they are doing, and they are not just enjoying what they are doing. So if it is something that you really, really like, coupled with the fact that you are taking up an area of law which is also financially rewarding, I think that's very important, because you see what happens is different areas of law will have a different niche attached to it. Let's say somebody takes up international human rights law or international criminal law. Now, the only downside to international criminal law is once in 5 years or 2 years or 3 years, there would be a mega case which would come before the ICC or a special tribunal like the International Criminal Tribunal for Rwanda, let's say, right? Or for South Ossetia and Abkhazia and all those specific places. It becomes very, very difficult for you to be attached to that case, right? Because let's face it, there are far too many practitioners in all those domains. So you must look at the financial viability and and in terms of the development of law, the prospective, futuristic development of the law. If you see a scope, then get into it and do whatever it is that you love doing. And for that, and to that extent, I think it's never too late to decide what your calling is. So don't take that pressure on your head if you can't figure out, if you don't know whether to choose X area of law or Y area of law. But most important thing, I think, for first year students is please do not come with preconceived notions. You see, if you come with preconceived notions that, I would only want to do mergers and acquisitions and nothing else because this is what I've been harboring, because an ex-cousin's friend who is now working as a principal associate in a law firm seems that, he says that this is the best option available. I think it's not so easy. You find your own calling, you find your subject on the basis of your interest in the subject, nothing else. And believe me, if you really enjoy working if you really enjoy working on your subject, then you wouldn't even know the extent of time that you are spending in it. It won't be laborious, it won't be burdensome. You will enjoy every moment of it.
Yeah, sir. So I think talking about how one has to find his area of interest, I think internships are one thing that play a major role in shaping that area of interest. if we do an internship, we get to know about do we prefer to go in that area in our future? Do we see that as a future? So, sir, since internships play an important role for an aspiring lawyer, as this is an opportunity when one could get a practical experience about the legal field. So what should be done by that person to get an internship, and how that communication skills help him in getting an internship?
See, I think communication skills are very, very, very important in terms of from the moment you first apply. Don't make generic emails or cover letters, because we receive hundreds of internships in our office on almost every call for internship that we release. The most distasteful thing for a prospective recruiter is to see that the person does not know anything about their profile or their firm. They have not done, the candidates have not done their research adequately. You see, now in this wonderful digital age, you have access to so many resources about law firms, about partners, about the teams, about lawyers, litigators, whoever it is that you are applying to, what kind of matters they've done. If you involve that personal touch in your cover letter or in your CV or in your resume or while you are having an interview, and you make the person believe that you are a fit candidate for that position, you meet the required skill set, coupled with the fact that you are willing to do whatever it takes to meet the goals, I think that assurance itself guarantees your position. You see, as lawyers, you will be selling ideas to your clients, to the judges, and also for consideration or rebuttal to the opposite side. You have to be convincing. There is no other way out of it. And for that, you have to be very, very effective in your communication skills. There is no two way about it. If you are not efficient with your communication skills, then you will always be underconfident. You will always be second guessing whether whatever you wanted to convey has been assimilated by the other side. But if you are clear in your head, you will be clear here, right? The same goes with your drafting. If you're clear in your head, you will be clear on the paper, right? So the step-by-step guide which worked for me is to have that idea in your head before it comes to your tongue. Organize it. Have a logical flow to that idea that you want to put across. Third, imagine yourself to be in a setting where you are performing. Every word that you utter must have a specific use. It must be able to convey a specific idea. It must be read to the ultimate objective that you want to achieve, which is, let's say, that job, that recruitment, that opportunity that you want to encash. And it is in furtherance of that opportunity that you must make your submissions, and it must be targeted, organized. That's how it works with recruiters, and not just with recruiters. That's also the essence to a very good advocacy. Unless and until you are organized in whatever it is that you want to communicate, you have lost half the battle. You can win provided you have structured what it is that you want to say, that you have thought about it from different perspectives. When you give them different perspectives, you would be surprised to see that the one that you feel is the most important may not be that important to the other person, but let's say your third issue may have found favor with the court or with the opposite side or whatever it is, right?
Also, sir, I was just curious to put forward a point that, like, we did talk about the skill set. Sir, how do you think about the bar on the year of student who can apply? Like, basically, like for internship, people say like someone from third year or above can apply. So I definitely get the point that, like, since you get into your third year, you start learning the core laws. But given to the interest or the curiousness of a particular individual, shouldn't it be like allowed for all the individuals?
It all depends. See, for instance, my office takes students only third year and above. But the reasons of us doing that is very simple. First and foremost, most of our practice revolves around Supreme Court and High Courts. you need to know Constitution, because Constitution there is not just substantive, it is also procedural. The procedural aspects of Constitution. You need to have an excellent command over CPC, CRPC evidence, because nobody has the time to sit and teach. Right? Most of the internship experiences, a common misconception is that there would be somebody who is going to, take a Cerelac in the hand and spoon feed you. That does not work with internships. There, it is on your own observational capacity, on the basis of your own retentive capacity. Whatever work is being thrown at you is something that you are expected to do, irrespective of whether you know the subject or you don't know the subject. So, the ideal way to go about is immense reading, researching till kingdom come, and of course, presenting a good quality work to your seniors, whoever has demanded that work of you. The only downside that we see is that there's a lot of procedural aspects involved with litigation. The stakes are very high. You cannot leave it to a particular person in a matter involving, say, 600 crores of international commercial dispute, right? And your research, because nobody else has the time to do it, that is why the research is being delegated to an intern, right? And therefore, it becomes all the more necessary for that person to understand that kind of responsibility, whether that person can shoulder it. You can't expect that from a first year or a second year person to be equipped to deal with all these things, right? Unless and until, of course, I've seen many people who use all their connections, etc., to get through law firms in their first year, second year, just to, show as a proud badge to their colleagues and peers, I got through this law firm. And the kind of work that I've seen them being given is deplorable. They are photocopy guys, they are scanning guys, they are take one document, deliver it to table number so and so guys, right? This is not where you are learning. In your first year and second year, please go to trial courts. Please go and work with NGOs. Those are the kind of places where you learn a lot, right? You learn the very basics, the ABC, so that next time you appear before the court or you work with an internship before a Supreme Court or a High Court lawyer, you understand the distinction between intervener, impleader, plaintiff, defendant, petitioner, respondent, appellant, respondent, and you don't mix all of this. These are very basics, right? Nobody's going to sit there and explain it to you. This is something that you and you alone can learn, right? And to that extent, I think communication becomes the key. Wherever it is that you do not understand a point, please raise a question. Please ask. Do not fear that you will be called dumb or that you are stupid when you are asking that question. You are not. All of us have learned in a similar fashion because we ask too many questions. In fact, I used to ask so many questions that my teachers would be a testimony to that, were completely bugged. At one point of time, they are like, "Itna sawal puchta hai this boy," right? But this is how you learn, and this is how you will be able to equip yourself, because if your level of understanding, the foundation of your level of understanding is through question answers, then I think it develops at a great pace.
Yeah, definitely, sir. But sometimes we face a question that the training provided by law schools in language and literature is not up to the expectations, as language plays an important role in the legal field. So do you think that the training of language and literature that is being provided in law school is sufficient, or do you think the focus should be increased?
See, it's a combination of different factors. First and foremost, of course, the formal education which is being provided in law schools and colleges is of quintessence. These soft skills are very, very important. It is expected of you to employ these soft skills, press them into service to get your optimum results. So you won't be able to have a conversation with a client without having those kind of skill sets, right? But you must also understand that question answering a client is different from cross-examination of a witness. Those are different sets of conversational skills that you would have to employ, right? Or thirdly, speaking to a judge. You can't talk to a judge in the manner you talk to a client, right? There's, of course, a difference of hierarchy, authority, and you need to be able to mellow down your speech. You need to have that different kind of diction. Your voice must be modulated so as to have that kind of conversation. So it's all different skill sets. And of course, I will be failing in my duty if I do not point out that law schools do not equip you with everything. They cannot. They simply cannot, because they can't visualize what area of law are you going into, right? So there are some basic, common, minimum basic skill sets that they teach you, and then they leave it to you as to how you want to go ahead with it. Say, for instance, mooting is important. I think everybody must moot. They must. I mean, it's not necessary that you make a career out of it by coaching other teams and other students from different law schools, or judging different moot court competitions. All of us have done it. I have done it. But after a point of time, I called it quits, because now the workload is so much that I just don't have the time for all of it. But right now, you don't have that kind of time. You have that luxury of a time with you, right? So invest, learn, try to do as much public speaking as possible. Try to get into or enroll yourselves into debating sectors, into moot court societies, into MUNs, whatever, call it whatever it is, that every opportunity that you get, work with legal aid camps. It's an excellent opportunity for you to understand what are the requirements of the client. You may have n number of things in law to tell your client, but your client does not want that kind of relief. What do you do? How do you get out of it, right? These are so many important things that you are not trained in law school specifically, but you can learn. It's not that these things are not around you. All that you have to do is to be observational, is to see whether these things will, those opportunities keep coming.
So, sir, we talked about the training given in law schools, and you being an experienced holder of law school. So, sir, I want to know about your personal experience of being trained in language and literature in law school, and how the training was helpful to you, and how it is useful in courts. Also, did you develop your own skills of using language in courts?
Okay, so it's a very interesting question. Of course, on the formal side of it, we were trained and we had law and literature in our first year, right? And we had those wonderful, amazing stress buster sessions with Dr. Prasannachu, who ensured that we had a very good time. Also, at the same time, we knew that we were learning a lot in the entire process. Those classroom exercises were fun. They were de-stressing, and it was something that we really looked up to, looked forward to. But I'll be very honest with you. There are certain limitations with any course curriculum. No course curriculum can train you to be the best version of yourself. You have to put those kind of efforts, right? You need to know, you need to observe to be able to communicate effectively. The first and foremost thing that you need to do is observe your peers, observe that one speaker who has the attention of the entire room, and see what is it that they are bringing to table. Look at their pauses, look at how effective and convincing their arguments are. Look at the manner in which they are addressing the gathering, right? And then you formulate your own styles. In personally speaking, I was interning in the Supreme Court, and I had the pleasure and the honor of working with some of the most renowned names in the profession, right? We have been going to courts and observing Mr. Nariman at work, Mr. Surabji, Mr. T.R. who unfortunately is no more with us, Mr. Ashok Desai, another great counsel of eminence, right? Mr. Salve, Mr. Sibbal, Dr. Singhvi, Mr. Rodgi. The list is just endless. There's so many brilliant speakers, equally endowed with the skill to persuade the bench. And it is there that we learned. It is there that you look at different speaking styles, different styles of addressing the court, different manners in which they organized, they structured what they were supposed to say. And in cases where we thought were hopeless, they were able to obtain relief for their clients. You see? And it is then and only then that you draw comparative analysis, see which of these fits your bill. And it is then and only then that you come out with your own style of art. You see, it's not that you are like just focusing on one person and emulating that style, because then you are just a copycat. It makes more sense for you to apply your own brains, see which style fits you, right? And it is then and only then that you become very, very adept at communicating. Because you see, one skill set may work with one bench, it may not work with another bench. Some bench may want you to go to the issues first. Some bench may want you to be very proper in your decorum while you are addressing the court. All of this will come by judging the judge. It's not the judge judging you, it's vice versa. The more you judge, the more you observe, it is then and only then that you become more convincing in your approach. The entire game that I have to stress on, the entire game is persuasion. You need to be able to persuade, because that is precisely what you're doing, right? You are not harping on, you are not, imposing your viewpoints. You are making the other person see the logic of things. You see, that if that person has to agree with some point, it has to be your point. And that person, and there's nothing more rewarding than that person using their independent, or thinking that they're using their independent thought process to come to the same conclusion that you are trying to put forth, and making that person, he or she, believe that it is they who are thinking, but it's not them, it's you who are doing this, and they are just playing to your game. And that game has to be so subtle that nobody understands it. You see, this is what persuasion is all about. Look at the background of the person, the kind of cases that they have decided, what works with them, what does not work with them, what would be your best point. There may be very good points in law, but which is that one point you would want to canvas first, so as to have the instant attention, and slowly work your way towards it. It's a wonderful exercise, but communication is so vast a topic that we can spend hours and hours on discussing different profiles, what works with one particular with one particular set of individuals, what skill sets is something that you must incorporate or imbibe. And I think that's what you must be on a lookout for when you are interning. Spend your time in courts. Look at them arguing a point of law, right? Look at them arguing when it comes to matters of discretionary relief. It's not a case where the judge is obligated to hear you. The judge may just dismiss the case because he does not like your face. Of course, it doesn't happen that way, but it may well happen, right? The person is having a bad day. They may just dismiss your case, right? So you have to be able to look at to observe these people, see what fits the bill, how exactly you're supposed to canvas your submission, because I think that's very, very important.
So, sir, I think this was the last question of this episode. With this, we are at the end of the podcast. So, would you like to give any concluding remarks?
Well, I think it's imperative that you put due attention to the skills that you are acquiring during and throughout your stay at a national or university. There are so many opportunities coming your way, in cash as many as you can. Of course, at the same time, maintaining that balance so that you are just not running from one place to another. Enjoy your time at law school, do whatever it is that you have to do, but make sure that you are productive at the end of the day. You are learning something out of the entire experience. Do whatever it is that you like. It does not matter whether you do modes, whether you do, whether you write research papers, whether you do MUNs or debating societies, whatever it is, that's your call. Do it, but ensure that you are enjoying the entire process and you are assimilating whatever you can, right? And I think that's most important. Nobody expects you to do anything more than that. You can all figure out, and if you are good at what you do, if you are willing to put in the hours of work, if you are committed to whatever it is that you have decided to do, then there's no stopping you. It's a wonderful ocean of opportunities. Just take a dive in, have some faith, and I'm sure you will do very well.
Yeah, it was a very insightful session, sir, with you, and we would like to have similar sessions with you in future.
Absolutely, it would be my
Thank you
pleasure.
so much, sir, for joining us.
Thank you so much, guys, for having me.